Good afternoon, everybody. My name is Jason Weiss. You are on the Ask Jason Weiss show. As all of you know, I am both a consultant, I am a coach, and I am a lawyer. So anything we talk about today will not be considered legal advice, and I will stop rocking so that I don't make myself sick. But nothing discussed today constitutes legal advice. Should you seek legal advice, consult an attorney directly. My guest today is actually an attorney as well, and anything that she says is also not legal advice. It's just general legal terminology, general concepts. No attorney-client relationship is created between myself and the viewers, or between Alice Denenberg and the viewers as well. We are here today just talking about law, and we are not giving legal advice. And that's it. Nothing you hear today regarding, we talked about trading last time, but this time we're talking about trademarking. And you should seek any type of information about trademarking, and anything you hear today, you should go ahead and speak to Alice directly. And that's what she does. So today's show is called Protect Your Mark. And the reason that we're talking about the mark is we have a trademark attorney, and we don't say specializing and we don't say experts, but an attorney who practices in the trademark field, Alice Denenberg. And she is live from the New York, New Jersey area where she practices. And she is somebody that, for me, was one of the phenomenal things that came out of COVID. I met Alice because when COVID and everybody started locking down and doing Zooms and doing conferences, she and I connected. And now she is my trademark, I'm going to say guru. I won't say specialist, but she is my trademark guru. And anytime I have a trademark question, I go to her and I refer my clients over. So that should show you what kind of trust that I have in Alice. So Alice, tell us a little bit about yourself and your practice, and then we're going to dive right in. And I got plenty of questions for you.
Sure. Hi, Jason. Thanks so much for having me on the show. I'm really excited. And yes, I second your sentiment about, the meeting during the COVID when people were kind of like getting together online and being able to kind of like expand their networks by meeting people like out of state and coast to coast where they may not have met those people otherwise. So yes, I echo that sentiment. I think that, COVID was to some degree a really great time for networking and has kind of normalized online networking that may not have been considered okay before. So I just want to kind of talk about that. In terms of my practice, my focus is on trademarks. I assist clients, businesses, small, large, anywhere in between, in securing trademark protection, either in the US or even anywhere in the world. And I filed pretty much in any country where somebody would be, reasonably interested in pursuing trademark protection. And then some others where maybe nobody's really interested in, but still wants to pursue the protection. And I'm familiar with the process. And I love to impart my expertise and experience to my clients and help them kind of navigate the waters and getting what they need for their business.
So one of the things that you mentioned in our pre-show discussion that you and I had, which was just very quick, and at the same time, something you just mentioned now, is you talked about trademarks internationally as well as domestically. So I'm just going to throw it out there, right? I have a trademark on one of my son's logos and images for the lacrosse stuff that he does, the long pole life or long pole for life. And unfortunately, I didn't know Alice at the time, so I went ahead and I learned how to do it on my own. But it's okay. I got it done. But it would have been a lot easier using Alice. I can definitely state that. But what are some of the benefits of, A, registering something for a trademark, and then B, where do you figure out, like, should I register it in the US or should I register it overseas? Like, how does a normal consumer, figure that out?
Those are great questions. So I'll talk a little bit about the US system, which in my view and in my experience is actually one of the most intricate and different than any other system around the world. And then I'll talk a little bit about how, as a business owner, you would consider filing outside the US. So in terms in the US, if you're like a US based business individual, either can file, you can file a trademark whether or not you're currently selling the product or if you expect to sell a product. But at the end, to ultimately secure your registration, you need to be selling your product, or, having it out in the marketplace. Sale is not actually the exact prerequisite. Or if you have a service, if you're doing a coaching service, you need to be providing that service. And they will not, the US system doesn't permit registration without what we call use in commerce. So they really want valid use, because they don't want people just picking a name and saying, okay, well, I'm taking that name for myself and nobody else can have it. They really do want, not only at the outset to secure the registration, at the outset of filing and or to secure the registration, but also they have maintenance requirements. The first one being between the 5th and 6th year after registration, a very unique, nobody else really has that 5th and 6th year after registration maintenance requirement, that you show that you do have continued use in the trademark and continued interest. And then after that, every 10 years, you have to renew, but you every single time have to support your renewal with showing that you're using the mark. And just in contrast with some of the foreign systems, in that case, like, anybody can really file for anything. So if you have a brand, and this happens to us all the time, especially in China, but it could happen anywhere, where somebody you just need to file it, and they call it first to file system, whereas the US is considered first to use. So, the US system, what I think is, like, it keeps the system honest, it allows for legitimacy in the business. It doesn't allow people just to reserve the name. Whereas in a foreign system, it's like whoever just happened to think of it first and files it can secure the registration to the exclusion of the legitimate brand owner. And a lot of times you have a brand owner, and at the time that they were kind of getting their brand started up, weren't really thinking about that, about extraterritorial protection. And then when they go to do it, and this actually just happened to a client I'm working with, somebody else already registered it, and they're now precluding you from securing your registration. And it's very difficult. Now you have this burden. In some countries, the burden is like, oh, you got to show you're famous or really well known across that country. And you're talking about like a brand that's really just emerged in that market. And now they can't even have their brand. So now it kind of just becomes an expensive or time consuming endeavor to try to kind of get that protection back. So the way we advise clients generally in terms of how do we decide where do we want to file, what foreign countries. So is basically like we say, okay, where are you manufacturing? Where are you selling? Where you just have distributors, or where maybe you expect to do it in the next, we can say 3 to 5 years, because unlike the US, which requires use to secure the registration, if you're a local US company or an individual, most of those countries not only don't require you to prove use to get the registration, but they don't require you to prove use at maintenance. There's a smattering of countries that have now started to adopt that requirement. I can just list them. Philippines, Mexico, and Argentina are now having requirements where you have to show that you're using the mark in order to keep it. But most of these marks in some countries, like I'll just throw out the European Union, a trademark can't even be challenged for non-use until it's been registered for 5 years. And then that's where, so they really give a kind of a generous amount of time to use your trademark, in commerce. And I do want to say at least for countries like the European Union and, like the United Kingdom and many other industrialized countries, you don't really have these, filers that are doing it in bad faith, like these people that are stealing brands. You may just have another brand that's very considered similar to your brand and could be a problem in terms of doing business in that country.
It's funny you were talking about that. So all during the COVID time and all of that, I went on GoDaddy and I was buying various different websites, web domains. I bought like covidlawyers.com or covidhrissues.com, and people wanted to buy them because they wanted to do all of that, and it was neat, and there was no restriction behind it, and I made a couple dollars here and there. But one of the things that you mentioned when you started talking about it was, and I don't know if you use these exact words, something that's already in use and intent to use.
Yeah.
So and I only know this because with my son's stuff, but maybe you can explain to people out there that like you don't need to have it in commerce in order to try to get trademark protection. And if you have it in commerce, you can still get trademark protection. Is that correct?
So I'll explain that. Okay.
Different avenues, correct?
Yeah, exactly.
All
so,
right.
and I'm talking about a US based business because, as we all know, as lawyers, there's always exceptions. So you're located in the US, you are currently selling a product or providing a service. When you go to file your trademark application, likely your attorney is going to counsel you to file what we call on a use and commerce basis. So you're selling your product. You have clients, ideally across the US or at least a different state, because they want something called interstate commerce. Or you have like some kind of a service, like I'll give Jason your coaching service, for example. You have clients that are hiring you. So you have use of your trademark. That's called a use and commerce basis. And to some degree, if you file it based on use and commerce, it simplifies and speeds up the process of securing registration. For an intent to use, let's say, Jason, you come up with this new concept of this product. Let's say glow in the dark lacrosse stick. I don't know. And you call it like glow stick. I don't know, something like that. I'm just making something up. But you haven't made anything yet. And you're looking for investors, for example, but you just love the name and want to get that out there. You can file it and you're going to say, well, I have an intent to sell products with this trademark on it, for example. I have an intent that I will have a website and my prospective clients will be able to buy the product for this, let's say, glow stick, this glow in the dark lacrosse stick. And you can file in the US with that basis, but you will not ultimately be able to get a registration until you've sold your product or had your product made and sent out, distributed, because it doesn't really have to be a sale, but it just has to be out there. It can't just be a pie in the sky. And then your website is up and running and I can place an order on it. Like that's what they want in terms of just in the simplistic terms, what they're talking about bona fide, which is not bona fide, meaning it can't just be a use. Like you can't just, take your son's lacrosse stick and dip it in glow paint and start giving one to your best friend and saying, okay, there's my use. That's not a bona fide use. It really needs to be an actual use in commerce that's legitimate in order to ultimately get the registration. But in the meantime, you're telling, because it's a public database that anybody could see, what's been filed, you're telling people, I intend to create this product and this is the name that I expect it's going to be.
And that makes sense, because I hear a lot of times, and you and I have talked about this with a client that I had, where they wouldn't do anything with their businesses and they wouldn't purchase websites and do anything until they had the trademark secured, which it could take 6 months to a year in order to get
6 months is not happening. They're not even looking at right now, just on the delays. It used to be 3 to 4 months after you file it that somebody at the trademark office would look at it. And now we're really kind of on a more 8 to more realistically 12 months before they're looking at it. And for a use in commerce basis application I would say an optimistic, maybe 14, but more likely 18 months from filing to reg. So
I mean, would you advise business owners? I'm saying from a legal side, not from a business side. You're not giving legal advice, but I have a couple of clients that are constantly coming to me and they're like, I have this idea and I don't want to buy the website until I get the mark. And I'm constantly telling them, buy the website. It's $19.99 or $9.99, whatever it is. And if you get the mark, awesome. If you don't get the mark, then you don't renew. Like I can't see, and maybe I'm wrong, but I can't see putting your entire potential business on hold.
Correct. Yeah.
Now, if you go ahead and retain you, and you go ahead and you put the application in for an intent to use or in use, can the client go ahead and start using it at that point in time and feel some sort of security?
So that's a good question. And there's actually things that we do before we file. And I really want to talk about that because it's important. So when a client comes to us and says, hey, I'm interested in this trademark, whether they've been using it or have not, and they haven't filed in the trademark office, we generally recommend doing a search. And the search is basically, it gives a lot of different information. One piece of information is going to tell me, what's the business risk of adopting and using and registering for this trademark? And for example, it might say somebody else already has a registration for it doesn't have to be, so the standard is not identical. It's confusingly similar. So somebody has already an existing registration that if we file, or application, they're probably going to block you. Now, that doesn't mean different thing. It doesn't mean that that's the end of the road. There could be different factors that, that we advise filing in a different way to, be able to coexist, or considering sometimes the answer is you really got to pick a different trademark. Sometimes the search might tell me that a mark is something called descriptive, which means it describes the goods and services. And those marks we would refer to them as a little bit weaker. They may be registrable, but they may not get on something the U.S. has 2 registers, also another quirk of the U.S. system: principal register and supplemental register. And supplemental register allows trademarks that describe a product that are considered descriptive to be registered, but it's kind of like a secondary register. So, and the last thing that a search could tell me, or at least one other kind of big one, is, can this even be a trademark? So there's something called a failure to function, where this proposed thing that you're trying to trademark is not even trademarkable. So there's a case that I can cite to. It's called Mama Bear. So a lady, and I will take her at her word, let's say she did arguably invent Mama Bear as a brand, okay? But the issue is she didn't really police it. And then now you start to see like all these retailers like Gap and H&M and and Target and Walmart, and they're all selling T-shirts and they say Mama Bear on it. So she lost the case where she wasn't able to show that it's an indicator of source. It wasn't even considered. It's not even a trademark. So doing the search before filing, and some clients, by the way, just don't want to search it and just file it, and that's fine. It's like diving in blind. You have no idea. Is there something at the bottom that's going to hurt me? I don't know. But if they're really concerned, that's where we would kind of do the search, and it will let us know like what to expect, and is this a good idea, and then after the search, then the client is at least aware of what the risks are when filing, and then we would file. And that kind of, in what you're saying, yes, I agree with you. Like for the $10 investment, just buy the domain name. If it's,
right,
we're talking about a $10 domain name, maybe $100, but like a $20,000 one, maybe that's where you want to.
Right. You don't want to go ahead and auction them and do all this. But hell, I searched on Google. Nobody's using it. It's okay.
So that's a good point. So, and hey, so the U.S., and again, I'm going to talk about U.S. law and not foreign law. So the U.S. actually recognizes common law rights and trademarks, which means unregistered trademarks can have priority rights even over somebody who files before them in the trademark office. And that's another reason you do the search. And you're right. Sometimes a common law result, which is something we may or may not uncover on Google. And just full disclosure, we use a company that literally all they do is they have, professional searchers that search, and they don't just search, the trademark office, they search state trademark databases, they search what's called common law, they search social media, they search specific like industry specific directories, press releases, to kind of give you a picture of, who's using this mark, is it in use, because somebody with prior rights of not even having filed an application could sue, could even file an opposition in the trademark office. The trademark office does allow people with what they call common law rights, no registration, no application, to challenge applications filed in the U.S. Trademark Office. So that's another reason that we really recommend that if you're serious about a brand, because you don't want to, proceed to file and then get like a cease and desist letter, or proceed to file and then get opposed, or whatever else. So like the idea is that we're doing some due diligence in determining, is this a good, what we call good business risk, reasonable business risk, before endeavoring on this like 18-month, or you're right, it could go longer. It could go, sometimes it goes up to 5 or even longer years, depending if it's intent to use basis or if there's suspension issues, whatever. And then now you're just waiting for a very long time. And, having done the search can kind of at least to some idea, like give you an idea of what to expect.
So we're going to go ahead and we're going to break. But when we come back from the break, I want to talk to you about some of the things that you talked about with various different words. And we're going to go back to that glow stick, because I'll set a scenario up for you. I know there's glow sticks. We all know there's glow sticks, but I want to talk to you about that. And we'll do the confusingly similar. And I'll tell you the slight problem I ran into on the one that I did by myself. And we'll get there. But you can reach Alice Denenberg. Burger.
I won't tell my husband you said that.
Yeah, no, I'm hungry, so I'm thinking about burgers. And my son, he's on spring break and just went to a burger joint. So yeah, Alice Denenberg. You can get her at www.grr.com. Phone number is 212-864 3900. You can also find her on LinkedIn, very active, very responsive, getting out of her shell, marketing like a champ, and I love it. I love it. I love it. I love it. That's where you can find her. And we're going to break for commercial, and we're going to come back and we're going to talk about words, images, logos, and all that great stuff. And that's what we'll go to. So, Cece, we're ready for our commercial. Thank you to our sponsors, and we'll be back in about 2 minutes.
Hi, I'm John Thomas. I want to share with you a professional products and services directory we call Going Solo Directory. And you need to check this out. If you want exposure to your business or are seeking professional product or services, this directory has it all. And that membership, for the many special features, you get the benefit of a worldwide exposure with a 40-minute video interview on an international business show showcase. All this for just one low annual fee. For more information, contact GoingSoloDirectory.com.
Hey, this is Jason Weiss. I am back with Alice Denenberg, who is our guru with regard to trademarks. We are not specialists. We are not experts, but it is the area that she practices in. She knows the stuff really, really well, and she's a great resource. And anybody that wants to protect their marks and their images and their logos and you spend time, you might as well protect them. Do it the right way. Hire an attorney who knows what she's doing, and she is somebody that will help you protect your logos and your images. And again, nothing discussed today constitutes legal advice. And should you seek legal advice or listen to anything that she or I say, listen to her, not me. It's not legal advice. You haven't hired an attorney, and there's no privilege. So one of the things that we were talking about when we broke for commercial, Alice, is that the confusingly similar, and you talked about descriptive. So just for example, we're talking about taking a lacrosse stick, dipping it in glow paint and calling it a glow stick. So I guess the question I have is, would you be able to get a trademark on the name glow stick?
So subject to a search, potentially, yeah, maybe.
Okay.
Again, the search would also kind of give me an idea of not just if the name is available, but would it be considered descriptive in the trademark office? And I could see, for example, what did other similar lacrosse stick marks get? And that will be informative on that respect. So the answer is, I don't actually know until I've done the search.
Gotcha. So I guess the point I was trying to get is I've had people call me in the past and they're like, oh yeah, I want to protect a name, and they come up with a name, and I've given the recommendation in the past. Look, I don't know if you're going to get protection, let's say, of glow stick, but if you have glow stick with an image or a logo, and you apply for that, you're going to have a much better chance at getting the protection. Do you agree? Am I incorrect in my belief?
So that's a good question. So if my search, or if it seems just obvious that the mark will probably be descriptive, then yes, adding an image under US law could be enough to take it out of that realm and get it either registered, potentially, hopefully on the principal register, or, again, worst case scenario, but still not a bad case, supplemental. Now, I just want to kind of address a bit about foreign law. So certain foreign countries, and I'll name them, Canada, and the European Union as a whole, the 27 member countries of the European Union, it's very difficult to register descriptive marks, even if you add some design element, unless the design element either meets a certain size threshold or meets a certain creativity threshold. So you do still need to, I do want to mention that the design should have some kind of bit of creativity. If it's if it's just like a circle, for example, that might not be enough, like a basic shape. They really are going to look for something a little bit more. So part of like when you do the search is the opinion might say to increase chances of registrability, you may want to consider adding a design or adding another term, for example, to increase that. So you're right in certain situations. And then what's the trade-off? So the question is, what's the trade-off? Well, the trade-off is that if you add a design to your trademark, now you're really limited to that depiction. And the word mark we consider like what we call standard character mark, the gold standard, because it protects any font size, stylization, layout. Whereas if you're limited by a design, now you're limited to that depiction. And companies change their depictions, their logos. And now if you're using it like differently enough, you may now ultimately, your federal trademark registration may really not be worth anything. So really the gold standard is standard character marks because of the broadness of the protection. But sometimes if the client is really married to a mark that is not something we can secure or that might be problematic with a standard character mark, that's where we're going to advise, or we may advise adding a logo to it, to ultimately get that. So you're right. And actually, yeah, go ahead.
This is the one that I was able to get, long pole for life.
Okay.
And we got it. And I had to use the logo. I had to be specific in the colors. I got it pushed through and it's out for publication as we speak from the USPTO.
That's correct. Yeah.
But, at the same time, it's funny because in order to get that, I had to disclaim the other trademark that I own, which is long pole life. And I had to differentiate it between a pole dancing mark as well. I'm like, this is for lacrosse. This isn't. They're like, you got to make sure it's not in the adult entertainment industry. I'm like, well, make it not in the adult entertainment. We're trying to do that, but some of these nuances. I mean, it took me forever and ever and ever. And again, I wish I knew you a year and a half ago when I started this process, because I would have just paid you and I would have been, done. It would have been so much easier. So I guess what you're saying is that the pitfall could be you're only protected, let's say, for this exact image, as opposed to, getting it for long pole for life. And I didn't even think about, trying for that because, I got the artwork done. I got everything done. That's how I wanted to do it. So if someone came to you and they're like, okay, and we'll use long pole for life for an example. Great. I want to protect long pole for life. And this is my image and this is everything. Would you recommend registering more than one mark, more than one set of words? Like I came to you, Alice, my 16-year-old son, he started a charity. It's called Long Pole for Life. This is what we got. What's my next step?
Sure. So like I said, really the next step is the search, and the search will tell me, can long pole for life exist on its own? And if you have your logo as well, we have clients, they have a logo and a word mark. Let's say we do searches on both and both are okay. We would typically advise that they be filed separately, because that means that once you secure your registration, you can use them together. You can, split out the word, you have your logo on the end. And then let's say you do change your logo in 5 years, word mark's still good. You just have to you would just potentially refile for your logo. And in some cases, actually US law allows for amendment of certain designs, if there's a threshold for it. It's depending on the commercial impression, but sometimes you can actually change a US trademark for registration and what they call correct it. You actually can't. The only other country I've found that is allowable is Australia. And almost any other country, if you vary your mark, you have to file it anew. They will not, but mind you, they don't have the use requirement, so it's less of an issue. But you really need to use it as registered to continue the protection, Jason. So for whatever reason, like you said, you filed it in color, for example. We actually usually file everything in black and white with limited exceptions, because let's say now you want to use purple or green, your registration is really limited to the color, the specific color that you've used. And it's to some degree limiting, because what if you get inspired and create something new, and you may have common law protection for the different use, but the registration is, the protection is as registered. So it is, some clients will maybe want to save a bit of money by doing both together. But generally, like I said, the gold standard is what you really want is your standard, what I would call a standard character mark. If
and one of my buddies just texted me saying,
okay,
I have a question. If I get a trademark, can I prevent others from using it in I think he's saying a website. So like if we got the trademark, let's just say on the words long pole for life, could we actually own that site, so it's okay. But let's say somebody else owned it. Can we get them to take that down?
So are you talking about, sorry, and when you say website, do you mean the domain name?
The domain name, like that. I'm assuming that's what he means. So like if we have this mark long pole for life, and let's say I did it the right way and I got it on long pole for life.
So now we're getting into what I would call like the UDRP, which is like the domain name, the rules on domain names. Part of it and I'm just going to throw out some factors. I'm not going to give a definitive analysis, but like if they had, let's say they registered long pole for life in 2000 and they just had like this domain and it's just sitting there. A lot of people just kind of, register domains. They don't put anything on them, or they might put some, part like links on them and stuff like that. It's tricky to say that somebody's infringed on you if they pre-existed you by a certain amount of years, right? Because people were just registering combinations of terms. And as long as those terms aren't typically like obviously what we'd call like somebody else's mark, but then as long as there's something, like you mentioned, you were registering COVID domains, like COVID
right.
HR, like those are very, like those are harder to secure as a trademark, but they're very descriptive, potentially even generic, and therefore not protectable. But like you're not clearly infringing on somebody's existing rights by registering. You're unlikely to. Again, the search would be informative on that. But let's say nobody had filed or registered for that and nobody was really using it beyond a fully descriptive use, you're not really necessarily infringing on somebody by just having that. But if they registered it later, let's say they registered it later and then maybe they're linking to your competitors. So that might be where you could have a basis to, maybe you'd send a cease and desist letter and demanding they transfer it over, or maybe that's where you go through WIPO. WIPO is the World Intellectual Property Organization that administers the UDRP, Uniform Domain Name, like basically the rules on, who gets to own a domain, and they have their own body of case law. And it's kind of like it's a world. I think that's really for domains that are not country codes. So I think the country code domains have their own little like sub courts for the countries. But like, for example, the .com is administered under the UDRP. So that's where you get into a different territory, which is like a different. So the answer is maybe, and you have to check like what are the facts and like when was this done and not done, and did they, maybe it's your, you and your evil, ex-best friend came up with this idea, and then he goes off and he's, and then he's doing it to try to kind of take something that doesn't belong to him. Well, those factors are kind of, would be something in consideration of determining who has the rights to the domain name, if that makes sense. But if it was like registered 10 years before you got your mark, that doesn't seem in terms of just general fairness to try to go against somebody who just happened to register this combination of words that you later decided you wanted and tell them that now they're infringing on you. Right. So it really is a fact specific. The answer is it's a fact specific inquiry. And that's also something that we would do when we do the search. It would also, if they actually list domain names, and I will check when I get that listing of domain names, I forgot to mention that in the list, and I'll see like, what are they doing with this domain name? And a domain name with an attached use can generally be considered good common law use. A domain name on its own usually is not considered to meet the burden of what we call bona fide use in commerce, just having registered the domain. But domain name plus a website attached to it, selling a product, providing a service, that's where you're now getting in the realm of common law use.
Now, so I come to you, you help me register the mark, and then I find later on that somebody's infringing or there's a problem. Do I come back to you? Do I have to hire somebody else?
Yeah. So not just me, like I actually work in a firm, and my firm, we're an intellectual property boutique. So like I do like a trademark aspect, we have attorneys that do copyright, and we have attorneys that do patent, and patent attorneys, for example, have to take a separate bar exam and be patent barred, or they also have something called patent agents, which are non-attorney barred, people that practice patent law. And then we have litigators, and we have people that do UDRP. So we really have like a team of people that, have different areas of experience that can assist. So if it's something I can't specifically assist with, somebody else in the firm, will have the knowledge or, about like patent bar, for example, and ability to assist in that realm. So no, my firm is like a one-stop shop. And I do want to mention, like, unlike a lot of areas of law, intellectual property law, trademark, patent, copyright is federal law. So I can work, not only do I work with clients everywhere in the US, I can work with clients anywhere in the world. I'm not limited to issues of state. So most areas of law, like, family law and criminal law, contract law, those are state law. Those are governed by the state where the marriage is occurring, or the contract was written, or the crime was committed. You have to work with an attorney barred in that state. For intellectual property law, because it's federal law in most cases, at least as to securing the protection and litigation, you could potentially need somebody local in that, in the federal court. But in terms of just securing the registration, or like getting a patent, you can use an attorney an IP attorney really in any state. So I work with clients just everywhere.
So one of the things that I've been coming across this more and more with some of my corporate clients, and I'm curious, a lot of corporations or individuals, they've been telling me that, I want to own all my intellectual property in either a trust or a corporation or a holding company. What's the pluses, minuses, or rationale behind it? I just don't understand it. So now you're educating me.
Okay, so I'll talk about it in the simplest terms, which I'll consider a corporation or LLC, which are the most common.
Right.
So if you file, let's say you are an individual and you file for a trademark in your own name, I mean, that's allowed, but by virtue of doing that you have no corporation or no company that's a barrier between you. Let's say you get charged with infringement, trademark infringement, your personal assets are on the line. So you really, like, as a really kind of a baseline, I'm going to, advise clients to consider having formed, and formation is really not a big, not usually a big issue, forming either a company or an LLC. In the most basic way, it's usually the same company that runs the business, but some kind of bigger companies, they'll have a separate entity that just holds their IP just because they're so big. For a smaller company, probably doesn't make sense. And so again, corporate law is one of those state law things, and that's out of my realm. I don't practice state like corporate law at all. That's where I would refer it out to somebody who's more, in that area. But at least in terms of IP portions, another issue is, like, what if the individual that holds the IP dies? Who owns it now? So their family's trying to, has to deal with having it transferred over, and you don't have somebody to sign over an assignment. So if you have this kind of, at least and I'm just going to talk about the trademark perspective because patent has its own issues with that too. But, if you have the company that's owned it, a company doesn't die, it's dissolved. It can't just, even if the CEO passes away, the company maintains. So you have other people that can take it over. You can sell it. You could sell a company, you can sell an LLC, and you can decide when you sell that, are you selling the IP with it or not? If it's filed as an individual, now you have that additional, it's kind of a more challenge. So I really do I don't want to say it's wrong if you file it as an individual, but there are benefits of having it initially filed, even because then you don't have to assign it, but initially filed in the name of some kind of entity. And then in terms of which entity it is, that would be another attorney that would advise you, yes, you should have a trust for whatever reason, or you should have an LLC because of these tax reasons. And that's where your accountant comes in with your business attorney, or you should have a corporation. And then of course that becomes also, it's a state issue, right? If my business in New York, am I forming in Delaware? My answer is, I don't know. Somebody else is going to tell you whether that's a good idea. But just as I do like to, I just think it's a matter of better practice just to have a company or some kind of entity, some legal entity own the intellectual property for the reasons that I just discussed, which is transferability and sellability and liability. So all those abilities are the reasons why you would want to do that.
So one of the other things that you mentioned, and it's the one thing I remember from intellectual property law in law school, was you talked about confusingly similar.
Yeah.
Can you just touch on what does that mean?
Sure. So confusingly similar is the standard of, is there consumer confusion to determine if a trademark is quote unquote confusing with another trademark. So the standard in the US is not that they have to be identical. They don't have to be identical to be confusing. They just have to be sufficiently confusingly similar, such that potentially a person, a shopper, a consumer would be like, wait a minute, are these the same owner? Are these different owners? And that's what I'm always explaining to clients. I'm like, listen, they don't have to be identical for there to be a problem. The trademark office, which is the first line of defense if you file something and there could be a conflict, is the one, an examiner, who's, by the way, all the trademark people at the USPTO are attorneys. They're actual barred attorneys. That's very different than certain foreign countries. They're just bureaucrats. They're just people that work there, but they're not actually attorneys. So you're dealing with an educated person that's making this determination based on how similar are the marks, how similar are the goods, how similar are the channels of trade. Are these channels of trade considered to be related? Are these businesses? So I'll give you an example of related businesses. So clothing is considered to be related to bags. Clothing is usually considered to be related to jewelry. Clothing can be considered related to cosmetics. Cosmetics can be considered related to supplements, because it's frequently that you'll have a company that would sell those products alongside each other. So if you're trying to, I'll give you an example. Let's say I wanted to register Andrew for purses, and I'm going to do a search. And let's say the search says, oh, well, somebody has Andrea for clothing, and those are different classes. Can I secure the registration? Well, an examiner could say, well, there's a likelihood of confusion between Andrew and Andrea. They're really only vary at the end, and right. Purses are related to clothing. So they would, what they call, issue a likelihood of confusion refusal and say, no, your trademark cannot go forward to registration. You can either try to argue it or if you want, you can always walk away. So that's really what that standard is. It's a legal standard for determining if there's a conflict between trademarks.
Well, I had a boss when I first started law school. I was practicing law, who would always say he was like the Fram oil filter. It's better to pay now than to pay later. Yeah. Meaning, do the research now. Spend the time. Don't just rely on, oh, it's a Google search, it's good, and I can buy the domain name. It doesn't mean squat. You need to contact a professional who was right here. And speak with her and run the search and do all of that and protect your assets and all of that great stuff, because you don't want to invest tens of thousands of dollars in an idea, a mark, a logo, a name, an image, and then find out you can't use it. So you might as well do it right the first time, and possibly not be so 100% dead set that, oh, I've got to have it. You might need to do it. And I tell clients this all the time. If you get it and you go down that path, buy the other names, buy .net, buy .co, buy whatever else you can buy, because you're only protecting yourself. And at the end of the day, that's our job. Our job is to protect you as the consumer and people out there. So I usually end the show, and here's the only curveball I'm giving you. I usually just try to give the hardest question that I could possibly imagine to end the show, so that my guest is going to say to me, boy, the show was great, but you stumped me on that last question. So here's the hardest question.
Okay.
Without giving up any confidences or anything, the most interesting thing you've ever applied for a trademark for, or that you've ever been, let's do this, the most interesting trademark you've ever helped a client get, because it'll be in the public record now that you already did it. So it's not a failed one. Yes. Exactly.
So that's a good, so just thinking of examples is tricky. So I'm going to be honest about that, but I do want to, on that thread, I'll tell you about the things that US law allows you to secure as a trademark, which I think is even more interesting. Okay. You could trademark a sound. So the Pillsbury Doughboys little woohoo, and the lightsaber that Han Solo's lightsaber, that's trademarked. You can trademark a smell. Play-Doh has a trademark for the smell of Play-Doh. You can trademark the interior of a store. So Apple has a trademark for the interior layout of their Apple store. Wow. You can trademark a color. So
Tiffany's.
And Tiffany's also has like their packaging trademarked.
Yep.
You can trademark like there's actually like just pretty anything that they consider, a hologram. Sometimes like a video clip, anything that can be considered a source indicator that you're aware that, this, like the Pillsbury, woohoo, that's Pillsbury. Like, that if anybody just says that connects you to the company. So anything that can be connected, the shape of a handbag, I believe, don't quote me on this, but Hermes has the shape of their handbag trademarked, which I think is important because there's so many infringements out there. Obviously the basic ones, which are the word and the logos, but it really does. I don't want to say the sky's the limit, but it's pretty significant. And a lot of other countries are now following suit, in that now they are expanding their definition of what can be a trademark. It's just so fascinating. So in terms of, let's see, the most fascinating ones, I've probably done some like pattern ones. Those are a bit tricky. They really are. Those more fancier trademarks, you really need to be, you're looking at an Apple level or like a bigger company. A smaller guy, it's going to be trickier, but certain shapes can be trademarked, certain product shapes. It can't be functional, but like certain aesthetic, like Coke bottle is the little the little fancy Coke bottle, I believe has a trademark. So there's really like an interesting, thing. I think like the Play-Doh case actually that comes to mind was, I believe the first one that allowed for a smell, that they provided proof that like when you open up a can of Play-Doh and you take a sniff, that's a very unique smell that is only attributed. It's probably their formula is probably a trade secret. But is only attributed to Play-Doh. Oh, the shape of a cookie, Oreo, I believe Oreo cookies, the shape, like the print on the Oreo, that's trademarked. So there's all sorts of interesting things that can be a source indicator under US law.
The lightsaber one was great. I mean, I literally have it on the background all the time, the movie Free Guy. And there's one scene where you put, like, I can close my eyes and I can hear vroom, and yep, that's a lightsaber, dude. That sound being protected. I never knew that. That's
they'll
really,
enforce
really
it too.
cool.
Anything Lucasfilm will enforce. So, And if you Google like trademark sounds, the USPTO has a listing, and they have like the Intel da 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 da.
Oh
the lightsaber. Like those are kind of the ones that really come to mind. But there's many, and you really, for those, you're gonna have to prove something called secondary meaning, which is the public understands this sound, this lightsaber sound, to be referring back to Lucasfilm, which is, I'm pretty sure they undoubtedly have no problem.
Oh yeah,
so,
and probably the not the lightsabers, but the shooters from the stormtroopers, though. Ching ching, I'm sure.
I don't know, but like any sound that is a short kind of, it can't like be a song, but any little couple bit of notes, I believe, can potentially be trademarked. So
right. And there was a whole thing in the music realm that I dealt with, way back when, how much you were allowed to sample in a music. Is it 5 seconds, 7 seconds, 10 seconds? The Beastie Boys were part of that litigation. And I remember that because I was a huge fan. And I'm just thinking, the Darth Vader breathing, that's probably something, that they have protection on.
Maybe just again, as I mentioned, common law. So even if they didn't register it, they might be able to enforce it. But that, what you were talking about with the sampling, that now we're delving into copyright law. So different area. But yeah, it could potentially be a little bit of an overlap, depending on like maybe the snippet has that lightsaber in it, in addition to other maybe dialogue or whatever that was infringed, and then maybe you could assert multiple causes of action, copyright and trademark infringement.
So I think the moral of the story is, when you're getting ready to start a business, you should chat with me about the business and about setting it up and doing all of that. And when you come up with your name, your slogan, your website, your images and all that, you got to get in touch with somebody like Alice. It's plain and simple. You can find her on LinkedIn. Just in case, for those of you that are listening, it's Alice, ALICE, Denenberg, DENENBERG. You can find her on LinkedIn. She's very, very responsive. You could also find her on the website for her firm, www.grr.com. Those are also the 3 first letters of my license plate of my car, grr. So grr.com. And you could always get her on the old-fashioned way of finding her, which is, calling the office at 212-684 3900. And she is just a phenomenal person, is very generous with her time, knows her stuff, and will point you in the right direction. And you should, know that if you work with her on trademark and all that kind of stuff, she's going to give you great advice and is going to help protect you. So Alice, thank you so much for taking the time to be here today. This was awesome. I got nothing more. If you got something, say it. Otherwise, we're going to wish you a great one. And again, we're going to just thank Alice for being here today.
No, hopefully I didn't say too much, but I think I covered the gamut of, what trademark is and what can be done. But yes, so
No, I think it's important. Again, these days with everybody going online and everybody with TikTok and all this kind of stuff, like, you want to make sure you're protected and you're not copied. I know it's not copyright, but you want to protect what you've put your reputation, your name, your logo, all that kind of stuff. Just hire an attorney, get it done right, protect yourself and see what you can do and what you can prevent others from doing. And that's what trademark law is basically about. Protect it, invest in it, get it done, spend the money. It's well worth it.
Trademarks are assets. Trademarks are an asset of the business. So if you sell your business, you sell it with the asset you could sell it with the asset of a trademark. So it has it's a business asset. It has a value, that can be like priced. So yeah. It's always valuable. And a lot of companies, when they're about to be purchased, they might be scrambling and filing for the trademarks, just to get that through, to add the value to the company when they're just doing the purchase. So
don't scramble around, get it done in advance. Contact Alice, find her. And if you're listening and you didn't write all that down, email me. I'm happy to share her information with you. Alice, thank you so much for being here today again. CC, thank you for running everything in the background. GoingSoloMedia.com. Thank you so much. Look forward to seeing everybody in 2 weeks. Thank you and have a wonderful day, everyone.
Thank you so much, both of you.